Wow. Wow. Anyone else out there feeling the bombshell that just went off? The FBAR bombshell that just went off, the Northern District of Florida. That is what we are here to discuss today. I have my long friends, Keith Redmond and John Richardson. Good morning, gentlemen, to you. Can you believe this? And Keith, do you even understand what's going on?
Well, you could somewhat. I mean, you filled me in the other day, so I have a basic understanding, but hence the reason for this podcast.
That's right. Yeah. Keith is our resident layperson. He helps John and I interpret reality to people. So he helps slow us down when we're going a little bit too far out there, which is early and often, I think. But
Right.
Keith does a
And
valuable.
like I said, when you do your numbers of Form 8572.1, let people know what that form is.
And that's what we're talking about. This is our first comment we got today from Andrew Yarnott. Exactly. Acronym morons rule the world. And boy, isn't that the truth? We're talking about FBARs. Beautiful conjure. Way to start off here. And this is my response to you, Andrew. Here you go. MRWA. So we're gonna get back there. So Keith runs a Facebook group. If you don't know him, he runs Americans accident. He runs American Expatriates. There we go. There's a link I was looking for on Facebook.
For residency-based taxation.
Right on. And so Keith's group is really more about the personal, real things going on. So Keith, you describe your day to me. You talk to people all over the world, and what is it that you do?
Well, I mean, I talk to people who are a bit lost, scared, frightened, worried or whatever, whether they're in the U.S. tax system or not. And depending on their profile and situation, it's dependent on their profile and situation. We take a look at what their real options are and formulate a short-term and long-term strategy for them based on their situation.
There it is.
And sometimes it may be that they need to get up to date with their tax compliance, sometimes not. Sometimes they need to stay away. It just all depends. Everybody's situation is a little bit different with a little bit nuanced.
I would say so, and I gotta, I do have other content on this channel, believe it or not, other than CBT and just the international issues. But I got
because you deal with Homeland Americans.
Yeah, I deal with that too. But I got to think a good, if I add up the videos we've done it has to be 400 videos we've done on the nuances. When we talk about nuances and the pain involved, thousands of views we have on these esoteric topics because it is so utterly humiliating, degrading, and it's actually financial terrorism. It actually is, and it's a strong word, but once you know what's happening. Yeah, you know what's happening.
And emotionally destabilizing.
Oh my God, there you go. Right? Emotionally destabilizing. Because Keith, one of the things, you have a lot of people who have non-U.S. spouses, and so you see, and we have a lot of those clients too. So
yeah,
it's awful. It's awful. And also with us today, this morning, is none other than the great John Richardson. The great one is here. I've been looking when I was the
great one. That's Jackie Gleason.
The great John Richardson is here. And this came out on a friend of mine, associate, just sent me a screenshot of this on Friday afternoon, right as I was leaving, of this court decision. And that's really what we're here to talk about today. We're going to be talking about this FBAR case that came out that it's mind blowing, and it's unbelievable, and it's great news. Boy, we've been looking for some great news here. And, and I think one of the things going on is that with all the news happening, people are focusing on the courts, and there's huge things happening in the courts. Some foundational underpinnings of tax and penalty administration destroyed and not coming back. So
it probably goes without saying, but FBAR is foreign bank account reporting, for anyone that does not know what that acronym is.
That's what we're talking about. Your report of foreign bank accounts, and John and I have gone over this so many times. We know this inside and out with all of it. John is an expert. He's really we have dug deep into the Bank Secrecy Act. There's a lot of strange things in the Bank Secrecy Act. So John, good morning to you. Have you read the decision? Have you read it?
I read it once. Yeah, I read it once.
All right. Well, we're going to go over it again. So it's going to be, I'm going to pull that up right on the screen here. So we're going to get to it right now. And here we go with it. Good morning. And by the way, good morning, John. How's it? Do we have our 32-ounce McDonald's Land Club? Yes. There it is. We are powered up now. All right. This is going to be one of the best episodes of all time. So John, good morning to you. So I'm going to pull it up here. Let me get this up here. Get my cry on there. And by the way, thanks everyone for joining us today. Hey, Don, great to see you, bud. Nice. Thanks for joining us from Switzerland. Right on, Professor of Stuffology. Nice to see you too. All right, yeah, let's get going. All right, so this is what's crazy. So glad to have you guys today. All right, so this is what's going to get into. This is it. This is it. We've been waiting for this. This is an unbelievable case. It's hard for me to control myself. So here we go. And I want to set up what actually happened in this case to give you a little bit of procedural background of this case to sort of understand what it is. This is very similar things that have happened to clients of mine, the process. Okay, so essentially this is what happened. As we go through the facts, we're going to get this. By the way, I got to find out who's on this legal team. These people are superstars. Whoever did this, I got to get them on the channel. This is amazing work. I'm just blown away.
It's Freeman Law in Texas.
Oh my God, I got to reach out to them and congratulate. This is an amazing work by them. Utterly fantastic. And so here we go with this. We have a taxpayer, Jarkesy Sagoo. Now, does anyone notice anything about his name? Does anyone? Keith, do you notice anything about his name?
Well, it sounds like he could be from outside the United States.
That's what I'm thinking too.
Possibly.
Yeah, possibly. I'm thinking, oh wow, that sounds like a name of someone who's potentially an immigrant. Maybe it didn't grow up in the U.S. and maybe had assets worldwide before they became a U.S. person. Would that make sense to you, Keith? That
Yes.
Yeah. And it's Miss Sagoo, Ms. Sagoo. So she failed to report her financial interests in foreign bank accounts for these 3 years. Okay. Now this is where the court is going and says Congress enacted the Bank Secrecy Act. Here we go. Here's our first acronym, right? We got so far the Bank Secrecy Act in response to increasing, and this is the government's claim here, by the way, increasing unavailability of foreign and domestic bank records of customers sought to be engaged in activities entailing criminal or civil liability. And they're going down for it. They're going through to see what this is all about. We get this here, a quote from Bittner. That's a helpful case. That was a helpful case. And then rather, the express purpose of the act is to require the maintenance of records and the making of certain reports which have a high degree of usefulness in criminal tax and regulatory investigations or proceedings. Now that's the sales pitch for it. John, do you agree with that? Characterization, and not that it matters. I don't think. That's the thing. I'm not really necessarily agreeing with the government's characterization.
Well, that's just quoting
right
from Section 5314 of Title 31. That's all it's doing.
And this seems to be more of the boilerplate. This seems to be like, okay, look, I don't really agree with their characterization of many things here, and I think if we looked at it, we could probably come up with a different way. But you know what? For these purposes, let's just accept it, right? So now we have Section 5314A, which I have up here. Sorry. Yeah. 5314A. That's the one we're always talking about, which I did not get up. Let me get that one up here.
I think you want 5321, don't you? The penalty.
And I have that one up too. I have that up too. And that's John's. Has an argument on that that's utterly wonderful. So this is basically the FBAR statute. We've done a lot about this, and the thing to ask yourself is, if you look at this, would this survive a Loper Bright analysis? Because when you're looking at what the law is saying it wants to do and what the regulation does, we find a mismatch, and you'll even see that. We'll see that in the opinion. But I want to, but this is the point you wanted to get to, John, right here. This is the section you wanted to talk about. And this is John's argument over here. This is the section of the law that allows the Secretary of Treasury to impose a civil money penalty on a person who violates or causes a violation of any provision of Section 5314. John has an interesting argument on Section 5314. Who does Section 5314 put an obligation on?
The Treasury Secretary.
There you go. The Treasury Secretary.
It doesn't put an obligation on anybody but the Treasury Secretary. I mean, if you read what it actually says.
Right. This is what it is. If you look at it, the Treasury Secretary shall require a resident of citizen of the United States or person in doing business in the United States to keep record file reports, keep records and file reports when the resident, citizen, or person makes a transaction or maintains a relation with any person with a foreign financial agency. So where's that form, Mr. Secretary? Secretary Besant, where's that form? That form doesn't exist. And so they created a different form about foreign bank accounts. So really, when you look at this, the only person allowed to be penalized for a willful violation would be the secretary. So it's kind of a poorly written law.
Well, that's right. I mean, that's the whole point, right?
Right.
The only statutory obligation on anybody is on the Treasury of the Secretary. Okay, that's it in the section.
And I think that's the great thing, because it's so really, this is how poorly of a law it's written. So when you actually break it down, it really can't withstand its own internal logic. It doesn't have an internal logic. So that's just one example of how kind of terrible this law has been organized. And again, when we go here, it's talking about something totally different. And it's trying to, considering the need to avoid impeding and controlling the export and import of monetary instruments, and the need to avoid burdening unreasonably a person. Well, this is supposed to streamline something. Like, this is supposed to be helpful to people, not punitive. This is supposed to streamline something. Well, this is creating something totally new out of thin cloth. And so I think that's one problem that we have with it. So let's get back to the decision. That's just our little tangent, and that's what you come here for, our little tangent. So Keith, checking in with you here. Makes sense so
Yes.
far? Okay, we didn't lose you too. All
It
right,
does.
well, you do have experience with us, so you might have a greater stamina than most people. So let's get back to the decision then. Okay, so we're going to here, and this is maybe why a lot of this characterization I would disagree with. It says section 5314 of the BSA requires United States citizens to file, or resident to file, a foreign bank and financial account report, FBAR, to the Secretary of Treasury. No, it doesn't. No, it doesn't. And now, now here's the site. Now they quote selectively, makes a transaction or maintains a relation for any person with a foreign financial agency. Yeah, they quote that, but they take it out of context. They take this out of context to say that, because the foreign has nothing to do, this doesn't mention a foreign bank account. And now here's where you get the actual law. This is where you get the actual law, but what are they citing? The regulation they made up out of thin cloth. And actually, they did charge Doug Edelman with a violation of breaking this regulation, because there is no FBAR law. They know it themselves. You can't violate what doesn't exist. And so that's a separate problem with it. And it's going to come up, and it's going to come up in this. We'll get to that. So dude, what a great explanation we have here. All right, so now we've gone through this part. The section 53A5C of the BSA authorized the Secretary of Treasury to impose civil penalties for willful failure to comply with the reporting requirements of section 5314A. But as John says, the Secretary of Treasury is the only one with the obligation. So again, when we look at this thing, it's highly questionable. Now, the maximum penalty is equal to greater of $100,000 or 50% of the balance in the foreign account at the time of the violation. Oh boy. Oh boy. I don't know what's going to happen there. And not that this makes sense. Not that we're really going to go and assess FBAR penalties against the Secretary of Treasury, but just to show you the ridiculousness of this law. And now upon assessment, and this is the thing, it's crazy. It's crazy how FBAR penalties work. That it's the IRS saying, you were willful. You were willful. You know why you were willful? We reviewed the record and we found you're willful. And then the IRS will say, well, we'll give you a right to appeal. Okay. You have the right to go to IRS Office of Independent Appeals. And this is what happens. You'll be talking to the appeals agent to say, hey, look, let me go over the facts why we should lower this FBAR penalty. Well, here's the mitigating circumstances of why this was really willfulness. And you'll have a conversation with the appeals officer, and appeals officer looks like he's favorable. Then the appeals officer will come back to you to say, well, I just spoke with the National FBAR Penalty Coordinator, who said that we can't do that and we have to assess this penalty. And I said, I'll be honest, that doesn't sound like you're very independent at this point. You're not taking it case by case, but you're applying trying to uniform law. This is the opposite of what appeals is trying to do. That's the opposite. So what we essentially have, and this is really the point you need to understand when it comes to FBAR penalties, the IRS is the judge, jury, and nearly executioner. They're the executioner on some things, but in order to execute their finding of fact, finding of law that they found totally on their own, they need to perfect that judgment in federal court and sue it. And that's what this is all about. That's what this case is all about. This case is about the government, federal government saying, hey, look, let's go over these penalties, this lawsuit. Ms. Sagoo was a United States person within the meaning of the 5314. And during this time, Ms. Sagoo held an interest in multiple financial accounts at financial institutions in Kenya, India, and England. Imagine that. Imagine that. Somebody, wow. In 2011, the total balance of these accounts was $1.4 million about. And those are the balances. Okay, so sounds like a hardworking person, probably maybe a doctor. Actually, that's what it kind of sounds like. A doctor, lawyer, someone, a high achiever, like a lot of our clients. A lot of our immigrant clients are really high achievers. And they're the ones who might have had more money back at home that allows them to come to the U.S. And so it's incredibly common. It's incredibly common for us to have that immigrant client who was totally unaware of these bizarre and esoteric reporting laws, and they get caught up in this. So could just imagine you're not from the United States and you learn about, well, because I have money, I have to do this. Why does the government need to know about my accounts overseas? What's this all about? And so despite, the court continues, despite 5314's reporting requirements to disclose foreign financial interests or financial interests in foreign financial accounts, as we just said, that's debatable, right? Ms. Sagoo did not timely file FBARs for those years. So on December 2nd, 2022, a delegate of the Internal Revenue Service assessed these penalties. Now, if you notice something that this doesn't say, but here's a trick the government did, and now I could put it together. Look at this. Wait a second. The assessment date is 2022, guys. Look at that. Look at that, right? But what years were these? We go back up. These for 11, 12, and 13. So here's a dirty trick the government did. You know what happened? You guys know what happened? The IRS got a motion. They got Ms. Sagoo to sign a consent to extend the statute of limitations. The IRS has 6 years to assess an FBAR penalty. 22 is a little bit beyond 2023. So the taxpayer in this case actually likely allowed, and that's what I would infer from what I'm reading here, because there's no way for them to do it otherwise. And that's what often the IRS will do, is they'll get you to convince you, extend this so that we can punish you more. And they used to not do this, by the way. They used to not be this. When you did a consent, it would usually work out for you. Now, when you do consent, they will often stab you in the back. So you got to be incredibly careful about agreeing to any consent to extend. They're simply just not reliable. And then they'll sit on the case and then they'll get back to it. All right. So here we go. And so back here, so it gets back to this lawsuit. We file a motion for summary judgment. Now here's what we have. Here's the arguments that were brought up, which are just beautiful. The 7th Amendment, the statutory language of 5314, and then they actually got your argument in there too, John, maybe. The statutory language of 5321A5.
Yeah, they did use that as well.
So they have, I love it. Look, we're not saying we made these arguments. We're just saying I love that they got these two big arguments. I love that they got them in there. So just fantastic job on their part. And then they actually added in the 8th Amendment excessive fine, which doesn't seem to be, there's not a lot of meat to that one. People have been winning on the 8th Amendment. The 7th Amendment, like this, is just beyond. And that's where people have been winning. So here's where we go. And this is what it looks like when you totally win, right? Therefore, the court grants Ms. Sagoo's motion to dismiss. And so all the other issues brought up, the court doesn't address, okay? Because here's the thing.
With prejudice. Didn't it say dismissed with prejudice?
Yes, I believe so. We'll make sure. So really what they ruled on was the first one. Hey, look, you violated the first one, but they did not get into issue 2. They did not get into issue 3 or any of these other things because, hey, look, we can kick it out now. And courts will go for economy. If they could just kick it out on an issue, it's gone. So that's what they want to do. Now, this is what is utterly fascinating. And this is kind of what I want to spend some time on, because this case, this Jarkesy case, which I don't think I appreciated as much when it came out, honestly. It's been a lot of followers, Andrew Prine, a lot of people at Common Law really pointing me back to this one. And so to see Jarkesy just becoming the case that's so important, and Jarkesy's the one that really undid is really laying the foundation. So Keith, let me ask you a couple basic questions about how you think the law works, right? as a resident, as our resident layperson,
Yeah.
if 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 someone sues you, right? It's just somebody sues you. What do they have to do? What
What
do
do
you
they
usually
have?
expect? Yeah, if somebody says, "Hey, Keith, pay me this money you owe me," and you decide not to pay you, what do they do in order to collect their money?
Well, depending on how much it is, they either go to small claims court or something higher to file a lawsuit.
Right, and that person, that person's going to have to prove in front of perhaps a jury, depending on how big it is, right? Perhaps a jury, because due process does sort of take into
Right.
account what's the nature of the what's at stake here, and the bigger the stakes, the bigger the due process. Does that make sense to you?
It makes sense. And I guess because and you have to help me guys on this one. I guess because it's not, is it because, how do I put this? It's not a criminal case, correct?
Right,
So
right.
it's based on the preponderance of evidence versus the reasonable
Well,
doubt.
actually, that's such a great question you ask it. I didn't think about that, but that's a great question to ask, Keith, because that's actually what there's actually a standard of proof required to prove willfulness, and there needs to be proof of a specific intent.
Yeah, and how do you prove
Yeah,
willfulness?
so
I
that's
mean,
another issue. If there was something like that, so let's just back up one step. So essentially, if somebody wants to take your stuff, the law says, "Hey, look, due process requires," and
right,
depending on how the risk of deprivation, the more due process. So if your life is at risk, right,
right,
you're going to get a criminal attorney to defend you all the way to appeal, right? If
yeah,
your house is at risk, it's the highest level of due process required. There better be a lot, making sure that you have complete notice, that you do understand what's going on, your rights are protected, right? So as it goes up there. So now this is the thing we know. FBAR penalties, these willful FBAR penalties are designed specifically to grab 50% of someone's bank
yeah.
account, correct?
But there's a part that I'm confused on, and I certainly don't want to go too much off topic. But if you don't have, as an American overseas, and you have nothing in the United States at all, and you are socked for whatever reason with an FBAR penalty, what is the process for collecting that FBAR penalty if you have no leverage? Where the IRS or the FinCEN does not have any leverage in the United States. I mean,
Keith,
they have to go through a whole process
Keith,
in your country of residence.
Keith, that's a
Yeah.
perfect question. Thank you. Thank you for that question, because this is the process by which they have to do it. And so that was always the question mark I would have when they're going ahead to do this. Like, okay, so you're going to sue this person that you're assessing FBAR penalties in federal court. So that's why they actually select people who they're going to sue. Because when they
Yeah.
do it, they need to see that money. They want to see it. They want to go after it. So that's really the thing, because the process is like, great, you assess an FBAR penalty against someone overseas. Now
And,
go
and,
enforce
and,
it.
and Anthony, so like this person with this particular court case, or Anthony and John, this court case, how did they even know that they did not file an FBAR on a particular account overseas? Is it because they filed it previously and they looked and they saw that there was a hole where they didn't file it moving forward? You see what I mean? How did
Yeah, I'm
they
not sure.
know?
This might be, what I'm thinking, there was some sort of voluntary disclosure involved, or
There was an audit,
it
Oh,
was.
okay. Okay. All right.
Thank you,
which
John.
is,
All right,
by
there
the
we
way, usually how these things start.
Got it. Okay. Thank you.
Thank you, John. So it was an examination. Oh my goodness. Okay. Well, thank you, John, for that. So yeah, there's not a lot of wisdom oftentimes, and that's why they're selective in who they're going to go after, for sure. So now we set it up, though. Hopefully we got it set up here, and I just check in. I know we got a lot of comments, and I want to make sure that there's not a good one, that we're not missing out one out of context, because we got a lot of great people. We're checking. Let me just take some time to check in with people. All right, so let's go here. David, good morning. Thanks for joining us. Oh, here's a question. Great question from David. Is this change likely to be applicable to anything beyond FBAR penalties? I got to think yes. And I think towards the end, I'll explain, David. I got to think yes, as we're looking at this. And that's what's getting me so excited. When we follow the logic here, we're kind of at a point, and I want to tie this together, because I know I have some clients, a lot of my friends facing 3520A penalties, 3520 penalties. A lot of my friends are. I know not everybody could afford to hire me. So I have some ideas for you guys that I want to get to at the end about what this means and how you might be able to use some of this to help you in your current plight. Because despite this, trust me, the government is still going after FBAR penalties. This is only in the Northern District of Texas. So it's not necessarily a binding decision on any other district. This concession really is only there. I think it's incredibly persuasive, and I think it must kind of be adopted by everybody. But as it is now, it's not quite there. But if we look at everything, and that's what I want to get to. We got what? Yeah, right. We're not going to get into this too much. But what is the definition of a purpose? Right on. And there we go. You're the age for all caps. All right, all caps. Here we go. Yeah, by the way, if you didn't miss it, this is what we're starting today off with. Not everybody saw this one. Andrew's acronym, Morons Rule the World, are short for AMRTW. So let's get back. Good morning to you, Sherry. Good morning, good morning, good morning, good morning. And that's the thing. Due process can't be all altered. That what is called when a court, and this is what we're getting to here, folks. This is what we're getting to, is you can't have statutes that take away your fundamental rights. Because this is the point I was trying to set up. When you're taking half of someone's wealth, or maybe even more than half of someone's wealth, you would assume the maximum amount of due process is required. But in this case, it's really the minimum. This is all done internally by the IRS. There's no independent review whatsoever. And you have IRS, and seriously, this is one of my biggest beefs with it. Title 31 is a criminal statute. The FBAR is a criminal form. It goes to the Financial Criminal Enforcement Network. And who is enforcing this criminal form? Why, it's the civil agents at the IRS. Civil agents at the IRS, just IRS employees, are the ones now in charge of administering a criminal form? This is utterly insane. I mean, this is how bad it is. And this is how bad the government has to abuse the law in order to assess these FBAR penalties. This is how outrageous it is. The most important thing, next to your life, your stuff, everything you own can be taken away through ad hoc determinations by the IRS with no law, no judges required. No judges required to be ruined. The job here is just and this suit was for the government just to perfect its judgment and now sue and totally ruin this Sagoo. So as we go down here, Ms. Sagoo is explaining this suit is not to determine whether to impose a penalty. Rather, right? This is it. Beautifully stated. That was my point. I should just maybe read this. To reduce an already assessed penalty to judgment. Okay. She contests the agency's underlying assessment is invalid because the penalized individual is guaranteed a jury trial in an Article III court before such penalty can be assessed. Yes. The court agrees with Ms. Sagoo. Oh my God, this is poetry. This is poetry. Here we go into it. And to your point, David, about where does this apply? Well, let's think about all the other places this could apply. Where does this reasoning all apply? The framers adopted the Seventh Amendment to secure the right to civil jury trial against the passing demands of expedience or convenience. Yeah. This right is of such importance and occupies so firm a place in our history and jurisprudence that any seeming curtailment of the right has always been and should be scrutinized with the utmost care. And this is Jarkesy. Okay? So, oh, Sherry missed the first 20 minutes. What happened? We were setting it up, I think, Sherry. I've been talking an awful lot. And I got to share the mic here a little bit. I've been talking an awful lot. I've been just so excited. So we have been talking about this case, what's happening, why it was brought, and why it's so important. What I'm getting into right now is it's an application to, number one, other districts and other applications beyond FBAR. That's where I want to bring this. So, John, can you think of some applications of this? The right to a jury. Can you think of any other instances where the federal government assesses massive penalties outside a jury trial? Can you
well, it seems to me that it could be applicable to general civil forfeiture. law. I'm not sure to what extent this would apply to penalties under the Internal Revenue Code. I mean, I just don't know. Remember that Title 31 is not Title 26, right?
Yeah.
And that's part of the reason why, they have to sue for these penalties to begin with, right? So, I mean, this is a really, really important decision because, and it's more important than Bittner, by the way. The reason
Yes, absolutely.
is because it establishes that basically constitutional rights apply to FBAR disputes, right? That's what it does. I mean, that's what this is about, right? I mean, these people had a Seventh Amendment right to a jury trial before assessment, for penalties to be determined by the jury. The FinCEN can't just, arbitrarily assess penalties. So that's why this is important. I am not aware, I'm not saying there isn't, but I am not aware of any other FBAR decision where there's been a specific ruling that people had constitutional rights, okay? Although we did have, I can't remember the name of it, we did have one coming out of Florida that may have suggested that. But this does seem to me that it opens the door to the Eighth Amendment thing in a much bigger way. Which would be, the excessive penalties thing as well, right? But for the moment, it's an important foot in the door. I mean, it's a huge problem for the IRS. It means they can't just assess these penalties.
And I think that's really been the structure of the IRS. They've just assumed automatic power to do anything they want, kind of at any time they want, and give some incidents of due process, but not really, give people a fair shake because look, they're deciding themselves. It's not an independent,
Well, I think the decision says something to the effect that without a jury trial, IRS, Treasury, what have you, becomes judge, jury, and executioner.
And I think that's right here.
And the whole point of the Seventh Amendment, which I think is stated in the case, or if it isn't, it's somewhere else, is to prevent the government from arguing on the basis of administrative expediency or efficiency. Let's skip the process of a jury trial. So, I mean, make no mistake, this is a hugely, I think, significant case. But what will be far more interesting is the government's response. Because understand, Anthony, that if the government appeals that, they might as well take a full-page ad in every publication in America saying that it's the position of the U.S. government that there are no constitutional rights when we want to confiscate your assets.
That's right.
Okay?
Well, I think the problem, though, is the government conceded. So I'm not sure how you appeal what you conceded.
Well, I don't know.
I'm not sure. But
you may be right on that. But I'm just saying that the problem here, right? I mean, when we really zero in on this, or not the problem, but what actually happened here was that a judge decides that in the context of FBAR penalties, or at least willful FBAR penalties, that people have a Seventh Amendment right to a jury trial. But you see, to say that there's a Seventh Amendment right to a jury trial is kind of to say that, well, people have constitutional rights when it comes to asset confiscation laws, right? And, I think that would be extremely upsetting to a government that is tyrannical as the United States government. So what do they do here, right? I don't know. Obviously, it will be interesting to see, but I'm just making a very narrow, I wouldn't even call it a conclusion, a very narrow possible observation. that if what happened was that we have a decision that says that people have a constitutional right to a jury trial before Mr. FBAR confiscates their assets, the basis of the appeal necessarily has to be no, people of America. Our position is that when it comes to the confiscation of your assets, you have no constitutional rights. So I think that's, I mean, if I were a government lawyer, I might consider the implications of publicly announcing the continuation of this.
So we don't think you should have a right to a jury when we want to take all your stuff.
Well, I mean,
we want to take half your stuff.
Look,
yeah.
At its core, isn't that what it is?
That's what it is.
Yeah.
It's a Yeah, that's what it is.
So I mean, leaving aside, the storied history of Mr. FBAR as an instrument of tyranny, abuse, and oppression, and I think a form of terrorism against Americans abroad.
100%.
If we remove those, since we're talking, flowery language, these self-evident truths, I mean, it's an unusually narrowly defined issue here, right? Do you have a jury trial?
Yeah.
The government wants to take your assets.
That's a really good point about this decision, how short it is and how quickly it gets to the issue, and it explains it very clearly. This is not normal. This is different. This is really a different thing. And now this is what I want to get to.
And by the way, just one more point to be
clear
why this is more important than Bittner.
Yeah.
Bittner was just a case about statutory interpretation.
Yeah. Mm-hmm.
Okay, that was it.
That's
right.
All. Yep.
And we have also remember that in the Monica Toth case, the Supreme Court refused to take the Eighth Amendment case. Now, as I think about this, I think we've even discussed this. There is that case out of Florida, actually. Now that my memory is coming back this morning, where there was a ruling that there was a ruling out of this case in Florida. I don't remember the name of it, and it's relatively recent, that the Eighth Amendment does apply in that particular case. But what we have are conflicting rulings, right? We have the Toth case where the First Circuit says Eighth Amendment does not apply, and we have this thing coming out of Florida saying Eighth Amendment does apply. So, the Supreme Court hasn't ruled on that issue. But I mean, this is a really, really important issue. I mean, the Eighth Amendment issue is, fundamentally, are there any limitations constitutionally to what the government can take, right? So, I mean, the government's position is real simple, okay? I mean, it can be understood. I don't know why they don't just write this in the statute, why they have this confusing statute. What the statute means, according to the government, is the United States government can take your assets at any time for any reason, without any jury trial. That's what their position is.
There you go, right? But you know what? Because and I think that's really what we have when you have.
Well, I don't know the complexity. Yeah, I do agree that complexity equals danger.
Yeah.
But what I am beginning to see about this is that what complexity does is it makes it harder to zero in on what's really going on, as I'm trying to do this morning to explain in simple terms what it's about. The more issues you can manufacture,
thank
the more
you. Here we go.
legalese.
Thank you, Eric. Here we go. There we go. It's
Schwartzbaum, absolutely.
Thank you.
Thank you so much. It is the Schwartzbaum case. And I remember we even discussed this. Schwartzbaum is an American hero. There should be, I think.
We did a podcast on this. Oh my God.
Statute erected of Mr. Schwartzbaum, okay, as holding up the principle that there are limits to what the U.S. government can steal from you.
There are limits. There's sometimes limits. Yeah. I thank you very much. Well, this is kind of what I want to get to. I want to go back to David's question, because this is really, what are the implications of this? David asked, is this change likely to be applicable to anything beyond FBAR. Well, take a look, guys. Take a look at how simple this argument is. And to my friends out there who are still dealing with penalties, and I thank you for reaching out to me. I always love hearing what's going on, keeping you updated. Think about this: wherever you are in your, whether you're in tax court, wherever you are, this is the argument. Whether you have FBAR penalties or 3520 penalties, 3520A penalties, or even 5470 penalties, which is a little weird story, which I'm not going to get into right now. But whatever those penalties are, they're the same issue. Don't you see? It's the same exact issue. Despite that it's basically because what we end up with, whether it's an FBAR, whether it's all these large penalties, we end up with all of these individual Seventh Amendment right because the agency already adjudicated liability without the benefit of a neutral fact finder. So it's the same thing. We have the same exact argument. So the argument that won in Sagoo, I think, is the winning argument, even though we have different sections of the law. That yes, Title 31 is FBAR and Title 26 is the U.S. tax code, but we still have a problem. We still have the government has this huge, massive problem. They're making this all up on their own. So,
Anthony, I think, as I listen to you talk and I see the questions squarely in front of my very eyes, it seems to me that the issue of whether these penalties under the Internal Revenue Code are assessable penalties or not may have some bearing on this.
I didn't want to get into that. But yeah, right. And that's a complication. But all right, I guess we do have to talk about it because there is the Farhi case, and this is the complicating part of it. Tax court has ruled that 5471 penalties and 8865 penalties are non-assessable penalties. Okay, so that the government has to sue to get. That's what tax court has ruled. The district court has ruled otherwise. So it's a weird thing where tax court is ignoring district court in a good way. So it's baffling. But there are assessable penalties, and those are your 3528, 3520. So that Farhi argument doesn't work there. So that's why globally, it's the same argument here. Hey, look, if we're going to be assessing these massive penalties, the Secretary of Treasury cannot be the prosecutor, judge, and jury and judge. And it's actually worse. It's actually far worse when it comes to these other penalties. And here's why. Because in this case, at least the government is suing to perfect its prior lien. At least they went to federal court. But when the government collects on 35, all these other penalties, they just go right to your bank account. They go right to your wages. There's no court oversight required whatsoever. The government can go straight in there. So the constitutional deprivation is actually much higher in Title 26 penalties because there's no mechanism that requires the Secretary of Treasury to bring to any court supervision. But at least in this FBAR, it's required. And so that's what I would say is it's the thing. This is applicable to other cases, and I think even more so. Because of how the penalty mechanism works. What do you think of that, Don?
Fun fact here. I think Keith will find this particularly interesting. Keith, you talk about the FAR case.
Yeah.
And, that was about 5471 penalties and whether they were assessable. So what happened, interestingly, was that the D.C. Court of Appeals overruled the FAR case and said that, they are assessable penalties. So interestingly, and Keith, this is, I think, of extreme relevance to Americans abroad in your group. As it stands now, only Americans abroad and people in the D.C. jurisdiction are subject to Form 5471 penalties. You want to hear that again?
Yeah, to say that again, John. Say that again.
So what happened in FARI was that the D.C. district overruled it. I mean, as an aside, I think it was a well-written decision. But the point is that they ruled that 5471 penalties were, in fact, assessable penalties. Now, that is good for that D.C. district. So as it stands now, it's now Americans abroad, right, are basically sucked into that particular district, right, because they're abroad. They don't live in the United States, that D.C. district. So as it stands, incredibly and shockingly,
oh my God,
only Americans abroad and individuals living in that particular district are subject to, essential are treated as 5471 penalties as being assessable. The rest of the country apparently is not. So,
Wow.
this practically shocks the conscience. It practically shocks the conscience. I mean, look, it's very clear that the government is at war,
Yeah.
with individuals. No question about it.
That is amazing, John. Thank you for that. That's amazing here. And I know Keith's got to drop off here.
Yeah,
and,
I actually do too.
and I do. So I'll let you guys go, and I'll finish up with any. If you guys need to hop off, I'll hop off.
I've
Yeah,
got
I'm gonna
maybe
have
2-3 minutes. I mean, if there are any questions that
all right,
might
let's
be.
see here what we got here.
Yeah, a couple minutes.
Let's summarize. I really think we need a succinct summary of what what this case means. Okay, so what does it mean? Means in willful FBAR cases, people are entitled to a jury trial before the IRS can, throw out this penalty stuff, right? That's what it means, I think. And, and that is, really good news for taxpayers because most people take one look at this stuff and they marvel at the unfairness, the capriciousness of it, etc. I mean, would you like to be how would you feel making a closing argument in jury trial saying, this immigrant to the United States, we're going to take 50% of their assets because of this egregious form crime against the American people? I think that this is the type of case where, I think the juries, they may not understand all the legal issues, but they'll see an unprincipled confiscation of assets when they see it.
And thank you. That's the point I want to make up because you guys said, why are you guys celebrating? The government can still ruin you with FBAR penalties. Why are we celebrating? Because effectively, look, the government has only been able to do this because they had a cheated system. A human being won't actually ruin another human being. And so a jury, actually, that's what a jury is here for, to stop government of abuse. And that's specifically why juries were bypassed by the government. Juries were intentionally bypassed by the government precisely because they wouldn't do this kind of crazy stuff. But the government certainly would.
Well, juries are, juries are historically sort of a defense mechanism against, tyrannical governments. And, look, let's be clear here. Okay, this penalty regime that the U.S. government is using, I call this the FBAR fundraiser, right? it is just over the top, and some of the and some of these other things, and these are very welcome decisions. The government, of course, will paint this as well, and then it may very well be, okay, this may in fact be, I don't know anything about the individual. It may very well be what they call a bad actor, but here's the bottom line, okay? It's only bad actors who make good law, all right? Because they're the ones who need constitutional rights. So in the same way that I remember saying that Mr. Schwartzbaum is a great American hero, what's the name of this person, Miss Sagoo?
Sagoo, yes.
I think that we ought to nominate Miss Sagoo as another great American.
She deserves a statue. Yeah? I think, she deserves one. That'd be, in their law firm. These guys, wow, I got to reach out to them. I'm just, this is hard stuff, and it's always, and it's always easy to read someone else's, work and get all, judgmental of it. But when you're doing it yourself, man, it's not as easy, it's hard.
Well, but I think that, the firm, I remember reading the initial brief or factum or whatever this is called. And I was impressed by the number of quivers, arrows in their quiver, so to speak, right? The number of separate and independent arguments that they made on this, and clearly, they're doing important work. But listen, but for Miss Sagoo, we would not be where we are today. Right. So, I think that we want to shout out, to all these bad people who somehow make good law.
But yeah, Miss Sagoo, if you want to reach out to me, by the way, share your story. Oftentimes, people do find, it's not, there's not a lot of other people talking about this case, so. Chances are she'd be watching, but you can reach out to any of us, and actually anyone. There's John's email. by the way. And these guys are going to hop off, and I'll handle all the questions because these guys have to go.
Yeah.
So I'm going to give final words to Keith. Keith, you got just to your call to action for people before you hop off.
Well, I mean, one call to action is we still need testimonials to send to John Richardson in regards to your dealing with double taxation. That's
right,
going to
yeah.
be very important. So just a reminder to people to send that over to John.
Mm-hmm.
Otherwise, I'm around, if people need to take a look and explore all their real options.
There you go.
And you have my, go ahead.
Yeah, go email Keith at US_overseas_advocate@outlook.com. If something, and really, I would say this is we will still be doing streamlined disclosures. Okay, just so you know.
Of course you're doing streamlined disclosure.
We're still going to do them, just so you know.
Right.
No, of course you're going to use the streamline. It's look, this is important, but it's going to take some time.
Yeah.
And by the way, I've only read this once, okay? But my belief is it applies only to willful, I think. And so there's all kinds of opportunity for the IRS, to behave poorly, okay? And I think they might just do that,
It's just amazing. It's
what do I know? Thanks, Anthony.
All right, thanks for joining us.
Time. Bye.
Bye. All right, thank you so much, John. And all right, I'll get to some questions. I want to thank everyone for joining us. I mean, this is just really a mind-blowing day for me, and just reading a decision that is written clearly is really mind-boggling to me as well, because it's so clear. So again, so what I would say is a few things going on too. Okay, so number one, the other thing I wanted to tell is my friends who are facing difficulty in tax court, remember what's going on. We have something called, it's up here. It is up here. It is called, hang on, Jarkesy. Okay. So this is what I want to talk about. Okay. This is an important case because this is what, based on what's happening, let's play this through. What's going to happen? Okay. So SEC versus Jarkesy is that the SEC has its own administrative court. Okay, this administrative court went to Mr. Jarkesy and said, hey, and I think he was a traitor. Hey, you did a whole bunch of things wrong. Okay, and it was really just the SEC didn't want to listen to what his defense is. They didn't want to listen to him. They just said, we found, through our process and through we gave you an appeal, but we find you're, due whatever, you have a penalty of $1 million, something, whatever it is, right? So he's going to move they're going to lose his license. Well, Mr. Jarkesy fought back and he said, well, wait a second. We have, let me get this back up here. I want to get my screenshot up here, right here. This is Jarkesy right here. The Supreme Court said, wait a second, Security and Exchange Commission, you guys are assessing basically a common law kind of fraud claim. Well, the common law kind of fraud claim is something that goes to court. It goes to Article 3. So here's two sort of different arguments that I think anyone in tax court now, anyone facing 3520A penalties, anyone facing 5471, anyone facing FBAR penalties, it's all sort of the related thing. Number one, tax court, which FBARs don't go to, by the way. That's the non-assessable one. So if you're in tax court, you can argue to say, hey, look, you guys can't decide this. You guys can't decide this. This is not a public benefit question. Okay, that's where they get their jurisdiction. This is not a public benefit question, but rather, this is a fundamental issue of common law. Do I owe this bill or not? That's like the oldest kind of common law in the world, right? This is a fundamental issue. Do I owe this money or not? And due to the massive amount of stake, well, of course, the right to jury applies. So the point is, and this is where I kind of get excited, there hasn't been good news. Our friend Solomon Yu has not been able to get Donald Trump to enact his promise to end double taxation. Unfortunately, has not. Solomon has been trying more than anybody else. We love his efforts, but unfortunately it hasn't worked. And in fact, what we got from the one big beautiful bill was something far more terrible. It's more complicated. It's actually a more complicated law that doesn't do anything that it said it was really going to do. It's all sort of a version of the promise, but nothing's really promised. And in the end, then double taxation is there. So kind of bad news, right? But what's happening in the courts? And what we see in the news is sensational and taking all of our attention. The big story, in my mind, is what's happening in the courts. And so Jarkesy, and this is the thing too, not only was Jarkesy was decided, but the district courts are picking up on it. So we saw Jarkesy get picked up, right? Where did it get picked up? Sun Valley. Sun Valley was a different administrative agency. That was Department of Labor. So again, we have Supreme Court saying SEC's administrative court illegal, not going to pay attention to them. We have the Third Circuit saying the DOL is invalid. Now we're having a district court saying that the FBARs are invalid. So this is all going the right way here, folks. This is all going the right way. So there's so many, and this is the point that people are missing. I am not sure if tax court is really going to be with us much longer. I am not sure if it is. It's an administrative court. And while it's argued that it's deciding public benefits, that doctrine really doesn't seem applicable. Public benefits was a doctrine created in 1848 when a federal employee was fired for embezzlement. That's what a public benefit was. And by the way, I did notice this, and I took notice of this. There was a case I was thinking of yesterday that fired employees, government employees, sued in district court to stop Donald Trump from firing them. But actually, that's insane, because public employment is a public benefit. That's the exact public benefit. But don't you see how these government employees made it so that their employment is now something that they can argue in district court, right? Their employment, which is actually a public benefit, gets the full due process, but their bill against you, which is not a public benefit, that's not a public benefit. That's assessing a bill against someone. That's not what it is. What I would say, and here's the difference. Here's the difference of what I would make. The IRS, what I would say the tax court does have jurisdiction right now is the administration of employee retention credits. Okay, that was a grant by Congress to allow certain employers money during COVID for when they laid off. Okay, and in that case, that is a public benefit. So I could see that saying, hey, look, you're not entitled to that as a right of common law, as long as the government isn't discriminating you on some other constitutional law. Hey, look, the public benefits would apply. So there, I would say, yeah, no, tax court can totally decide things like that. But when the tax court is deciding a bill that goes against you, it could take your stuff. We really need a court of law, of which tax court simply isn't. It's an administrative court. So that's the big news. That's what I see happening. I see that happening, folks, that tax court is going away. And now, look, I might be getting way ahead of myself. Well, you know I am, because it's my style. But where I'm going with this also is, let's just think about what's happening, folks. Let's just back up and think what's happening, okay? We have the IRS bragging about that it brought $10 billion in penalties from its OVDP programs and it's all its things. Well, every single one of those penalties I can think of, has all been decided without a jury trial. That is, every single penalty is illegal. Every single penalty assessed is illegal. And not only that, the government's threat of assessing penalties illegal. The government's threat to say, look, we don't even have to go for a jury. We're just going to assess this on your own. That was impermissible. That was duress. You're taking away someone's right. You're telling them, yeah, we're not going to give right to a trial, so you better take this. So you see what they did? Say, if you don't enter into this program and pay us this money, we are going to automatically assess you a 50% penalty. That turns out to be illegal, right? So what I'm thinking here, folks, and if anyone is here, because I do need a sponsor for this. I do need a sponsor. Been reaching out. If anyone is admitted in front of the Court of Federal Claims, to reach out to me. If you could reach out to me, because I am thinking that might be the appropriate venue to file a class action lawsuit against the federal government for its FBAR terrorism, because they have been doing this since 2009. Actually, a little bit earlier. They've been doing this since 2009. And by the way, the creator of the OVDP program, I talked to him. He's an attorney in private practice in Miami. And he told me, he goes, look, this is a program for criminals, actual criminals, not people who didn't know and not people who are living overseas. This is not what it's for. So the IRS took this program in the penalty bonanza that they went, and they unleashed a torrent of misery, pain, abuse, What has gone on? And I have clients right now where the IRS is illegally attempting to collect FBAR penalties right now, and bending laws, breaking the laws every which way. It is going on right now, but I'm seeing it. It's coming to an end, and it seems like it's coming to an end because Jarkesy, sorry IRS, you are not the judge, jury, and executioner. You are under this jurisdiction of a court of law, and that court of law is not you. That's where we're at. So that's kind of the big idea I have. So now I want to just go hit some questions, hit some comments. Thanks everyone for joining today. Really appreciate it. Great audience. This is one of my really excited to do this one. So let's get to some of the questions that we have. All right. So thanks everyone. So all right. Hi ho, Sherry. Good morning. Good morning to you. Oh yeah, I did give you that recap, Sherry. So thank you so much. And here you go. Great question. Great position. Foreigners have the right to common law too. That's right. You have the right to. Just because you're a foreigner, common law applies. Thank you very much. Donna Williams is the people. We are the people. We are people. And Professor Stafalchi saying they're not going to appeal. I agree with you. And exactly for this reason, I agree with you. They will not appeal this decision. The issue is that the IRS is going to say it's limited to the Northern District of Texas. That's going to be the issue. But I think they're going to have some problems trying to explain themselves away on that one. By the way, and that's what we're talking about. Again, Rob B, thank you so much for bringing that up. When we're talking about 53, this is the really important thing. Thank you. I do want to just go back to that point that I brought up in the middle. People might have missed this up here. So let me get to the screen share. So we've gone over the law. Here's what they're saying. Section 5314A of the BSA requires a citizen to file of FBAR. That's actually not true whatsoever. That's the assertion by the federal government. Because again, we could just go here to the statute. We say, no, it doesn't say that. It doesn't say anything. It says records and reports on foreign financial agency transactions, the import and export of something. If a foreign bank account could be imported into the United States, it's not foreign anymore, is it, right? So it's, this is a statute regulating something in commerce, whereas the FBAR is regulating something not moving in commerce. It's just the bank account somewhere, right? That's what it is. And so, all right, so Sherry's got a comment here. Sherry, I was going to move to Buenos Aires and feel that with all this paper will make any move a hazard. And so, I know, right? That's what we talk about when we talk about the terrorism, Sherry. That this unbelievable, like you don't know what to do. It's crazy. And yep, absolutely. Tax court is not a court, but I do argue tax court. Yeah, no, I have a few things going on in tax court right now. And, it's a delicate touch. It's a delicate touch to say, hey, by the way, you might not have any power here, right? And this, yeah, okay, so Matt, thank you for joining us today. Our government doesn't typically make their intentions known. So it appears to the majority as being fundamentally... Oh, yeah, good point. Yeah. We're not exactly dealing with an honest and upfront government, right? So that's kind of, they don't really want people to know what they're doing, and they like to hide stuff. And that's really, about the FBAR tyranny. I have hundreds and hundreds of hours about it, and people watch it. Now, the thing is, not a lot of people watch it because it doesn't affect a lot of people. So they don't want to really let everyone to know what they think of you. But this is what the government thinks of you. This is what the government, if you happen to do this, just because it doesn't affect you, it doesn't mean this isn't what the government thinks of you. You're just some idiot to penalize. You're just some idiot to own. Because there was some stupid thing you didn't know about, they can just go and ruin you. And now these government, these people working in these governments, they feel good about themselves, I guess. Hey, we did our job today. We ruined someone. We ruined someone with dementia. And that's also the fact that a lot of you guys know that. The IRS, who they penalize the worst is those with the dementia and those who are underrepresented. That's who they love to go after. It's so sickening. And I mentioned this before. IRS employees have to resign from their position after being forced to do what they're forced to do against people. They're told, you're going to go after the big fat cats, but who they go after? The minnows. They're looking for those minnows. That's what they do. So thank you for that, Matt. Yeah, you're exactly right. Rob, yeah. Our good friend Abraham Lincoln changed the entire administrative process. And at that point, you could really say, it's hard to say when did the United States really become an all-out tyranny? It would really be, I think, the Civil War. What Lincoln did was insane. And now what's also worse is that the federal government is allowed to give its side of the story. It gives its side of the claim. Well, we fought it for slavery and we're about preserving the Union. And none of it's true. None of that's true. None of it's true. It was about imposing a tax on the South. It was about creating a war. It was about creating a war to impoverish the South. That way, all that Southern property could be bought up by Lincoln's buddies for a song. And that's exactly what happened. Imagine that. Imagine that. That's exactly what happened when they went to war, because, you know, they were jealous. Because this is what people don't understand. The South was incredibly prosperous before the Civil War. And by the way, only 2% of the population owned slaves. Only 2%. So it really wasn't about slaves. Well, the Southerners didn't care. What they didn't want was the North ruling over them. That's what it was really about. Original jurisdiction, this is what we're talking about. All cases, they cannot statutorily redefine it. They cannot, which they're doing. It's all legislative interference. That's the word to think of your head. It's so helpful. Think of this all as legislative interference with your inalienable fundamental rights. Meaning, even if you voted for the thing that's removing your rights, you can't, because it's that inalienable. And this is where I would say that, you know, the arguably is that Lincoln set the stage. It receded. But then FDR came in and finished a lot of the magic that Lincoln did, because a lot of the courts came up with ridiculous things to continue to deny, you know, to expand the power of the courts, right? Again, the New Deal court really said this with a straight face, that wheat grown in your own backyard for your own personal consumption moves into interstate commerce. That's actually your New Deal for you. And by the way, that wasn't really restricted until what? Like later, much later on, where they actually said, "Wait, you can't do that. You just can't do that." So there's a lot of things there. You know, FDR, Lincoln, FDR, really two of the most destructive U.S. presidents. And unfortunately, people don't see that. Unfortunately, they'll still, you know, they still will think FDR and Lincoln are good people, but what they did to the rule of law is undeniable. And I think that's one of the surprises. You go in law school, you're just reading this like, oh, wait, so Lincoln suspended the writ of habeas corpus? I thought he was the good guy. Well, he must. He's a good guy. He always had good reasons, but he actually didn't. No, he was just there to censor people for his illegal war. That's what he was doing. Don, thank you so much. Yeah, this is thanks for joining. Look, I love the stash. Look at that. Oh my God, Don, you still rocking that stash. I love it. Thank you so much. I really appreciate you joining us today, Don. Thank you so much. Jury nullification is the only, well, Rush, you get some help from the court too, but that's the other thing too. Juries don't realize they're there to decide law and fact, right? But of course, there's statutes that say you're just there to decide fact. But no. In no way, shape, or form was the understanding of a jury trial was that juries only decided fact. They can absolutely, totally decide to nullify some stupid thing they don't understand or agree with. That is absolutely there. And so really one fact is to get everyone aware. If you are in a jury and you can't find the victim, if you're in a jury, you're looking like, where's the victim? I want to know the victim. Who's the victim in the case? And you have some woman standing up to say, I represent the American victim. Like, there's no victim. There's no victim. You need a victim. If you're going to convict someone, have a victim, right? There is one. There's a case out of, oh, thank you for that. A willful FBAR penalties would help. Oh God, we got to look at that. Okay, there was an FBAR held up a jury. Oh boy. All right, that's insane. Thank you for Eric. I'll have to look into that. If you happen to know that site, send it over to me. You want to email me, by the way, and anyone here. If anyone wants to email me, here's my email right here, aparent@irismedic.com. Okay. So yeah, if you want to send me anything you want me to take a look at, oh yeah. So thank you. Here we go. What do I mean by IRS agents resigning? They resign because, yeah, that's exactly right. They hate to do the job they're forced to do. That there's someone I follow, Howard. I follow him on Twitter, Howard Knudsen. He is a fascinating person to follow. He posts moderately, but he worked at the IRS and he tells his story online. I try to get him on the channel And he said, he goes, I still have people at the IRS. I don't want to be too inflammatory. I'm like, well, I don't know if you read your own post. You might be already. But, he said this. He basically, he started work at the IRS in 2011, something like that. And he or maybe a little later, and he was working. It was he's like, yeah, he was there. It's like, yep, I'm going to be, tracking down on people who are evading taxes. Well, what he found out again and again is that no, he was just getting people who were very unsophisticated, who made simple mistakes, but he was advised to jack up assessments against it, even if they couldn't pay. Especially if they couldn't pay, to jack up these assessments because it built up his stats. And so what he describes is that he had physical manifestations of the evil he was doing in his job. He had physical manifestations. He had a whole bunch of health problems. He went, sought mental health, and it came out to say, look, Howard, you want to get better, you got to quit the IRS. And so I love watching his Twitter feed, because he quit the IRS. Now he does tax prep. He does, and an honorable guy like that, I got to imagine he's going to be a pretty good guy. And now he's doing tax prep, and he chases waterfalls in his spare time. And so he's like, I just love it. And he's living healthy because he's living a job that doesn't require him to be evil. And that's really one of the things that we have is that, look, a lot of people aren't evil, but what they're asked to do, what they're done, their job is so segregated and split up and compartmentalized that they're never the one who's doing it, but in conjunction, they're doing the most inhumane things on the planet. And I always say that, the word draconian isn't really applicable, because that would be an improvement. If we had a draconian tax and penalty regime, that would be a vast improvement over whatever this is. This will be remembered as history's worst tax regime, and it's not even close. So that's what I mean by IRS agents are forced to resign. The people who actually have to be the one to look at a taxpayer in the eye and say, I'm going to ruin you because my boss told me to. You can't do that that many times. You can't do that forever. It's gonna weigh on you. And so that's why a lot of them just have to quit. And so then you got to remember, well, who's still there? What kind of person could still be there? I'm not going to offer much more judgment on that. We do have many ex-IRS employees working for us and reaching out to us. So Saddam is the case. All right, thank you. I'm going to take a look at that. Very interesting. Thank you so much, Eric. I appreciate that so much. And thank you so much for joining today. You've really helped out a lot. Curious as to what your story is. If you want to share, if you want to send me an email, creating a serial abuser, absolutely. Following orders, absolutely. Yeah, there you go. Right. Bombshell. Yeah. Oh, by the way. Yeah. And here's the point. Yeah. There was slavery. I'm in the great free state of Connecticut. We had slavery. And the problem why we didn't have a problem with slavery is because up here, we sold our slaves to the South. So now all of a sudden, our morality didn't cost us anything. So it's really funny. So yeah, no, the slavery question and, slave auctions were closed on a Saturday. Look into why. Look onto why slave auctions were closed on a Saturday. You might go down a road that, I've gone down that road. Some of you know that. So go down that road. And there's a lot of discoveries and who was really behind the slave trade. And were those people the same people who held the U.S. credit? Were those the same people, the same buddies of Alexander Hamilton? Were the people involved in the slave traders the exact same people that the U.S. Constitution enslaved every American to? And this is something to think about. There was no national debt until the ratification of the U.S. Constitution. And so I think a very simple claim could be made that the primary beneficiary of the U.S. Constitution was not the American people, but the foreign creditors who speculated on the war bonds to free America from the Revolutionary War. So it goes way back. It goes way back. Oh my God, is this right? Is this actually right, Don? Lincoln sold Mary. Oh my God. Yeah. There you go. Don, that says a lot about, thank you so much. That is absolutely right. And that's where people can find their morality very quickly, right? When it doesn't cost them anything. And then anyone defending Lincoln, folks, there's not one other civilized country that needed a civil war to end slavery. They just ended slavery. That's all they did. They just ended it. You actually didn't need to go to war. There's no evidence that that's what it was done. Again, it was about taxation. That's how taxation is how I got red pilled on Lincoln. Again, for some of those who know, just reading books, and then you start reading about these things, and you're just like, wait a second, this is not at all what I was taught. Lincoln is not the good guy. Yeah. And the Articles of Confederation was a much better document. Correct. The U.S. Constitution was a sales pitch of liberty. It was a sales pitch of liberty, but all it was a debt instrument. The U.S. Constitution is a debt instrument with a sales pitch of liberty. But this is what's exciting. This is what's totally exciting me. We actually have a court enforcing the sales pitch, which is really what I'm saying. Like, hey, look, guys, you sold us. They sold us Bill of Rights. Like, oh, this is going to protect your constitutional rights just in exchange for paying this debt. Okay, we paid the debt. Where's our rights? So this would be a great way to enforce that sales pitch, because the Articles of Confederation. By the way, I am not necessarily as opposed to the U.S. Constitution as long as the common law was applied. As long as it was, because a lot of the abuses would be abused. So I'm not necessarily as opposed to. I do think it was a hustle. But I think that people like Jefferson, who were for it, they really were. When you think about Jefferson, that's weird. Like, why would Jefferson be for it? But he was, because he's thinking, no, the common law is going to apply. It's going to be fine. So I would say those who ratified it weren't necessarily, and those who supported it weren't necessarily bad guys. That's what I would say. I wouldn't say they were necessarily bad guys. I think they were misled. And they were hustled. There was a hustle all over the place. It was a total hustle. When you go, why did all those war bonds? Why were all those war bonds sold at a steep discount? Research that one. So all right. So I think all right. So we got this. Yeah, there we go. Yeah, right. Yeah, Rob knows. Rhode Island. Oh yeah, was built on Newport. Newport was closed on the Sabbath. Find out when that was. You'll have a lot of answers. Trust me, folks. That's going to explain a lot. And a lot of what I've been saying is going to make sense. I'm not going to get into too much. And yeah, exactly. It's a rebranding of East. That's exactly. Rob, you're exactly right. The U.S. Constitution is a rebranding of the East India Company. That's what it is. And that's what it is. That is such a great point. I really appreciate that. All right, we got a little longer than normal yesterday. I do want to thank everybody out there. And if anyone is admitted in the Court of Federal Claims, if you could reach out to me, I really appreciate that. I do want to start getting the groundwork laid on this. And I think if you are admitted yourself, you probably would want to get in on this. Maybe we want to talk about how to start and frame up a class action suit. Again, the government has taken $10 billion from Americans without a trial, illegally. I'm saying that has to come back. I'm saying whatever their statute of limitations don't apply, it's all fraud. There's no statute of limitations on fraud. So that's the point. That's really where I want to get. So please reach out to me with that and any other issues. And there is a lot of tax court going on. And I have been saying we've been picking up more tax court cases. And there's a lot of things they're doing differently. You got to watch out for. You got to watch out for. So that's something you need some help on. You can reach out to us. I really appreciate that. And by the way, if you're looking for tax prep, please consider hiring my firm, Iris Medic. We do tax prep. We do a great job. And it helps support this channel. That's why I do it. It does help get my name out, and it does help us do a lot of great work and meet some fantastic, wonderful people who we enjoy helping. I know some of them are on this call. I really appreciate everyone joining us today. This is Anthony Parent for Keith Redmond, John Richardson. There you go. Right, exactly. There's what we're going to lead. Thank you very much. That's our conclusion. Thank you very much, Donna William. Thank you so much, everyone. Brilliant people today. Thanks so much for sharing, making this one of the best episodes ever. Really appreciate it.